It's just when my client finally put her foot down and said, I want to move forward, it's time for my son to transition home. That's when the guardian started getting upset, which I get it. She's had him for 5.5 years. I get that there is a strong bond.
I was notified by the person that owns the home she was living in that she was squatting.
It's not appropriate for the guardian to be saying, you're my son, I'm your parent, this is not your mom.
I don't say that.
So where are we at on this one, Miss Jocelyn?
So we were supposed to move to phase 4 in March. My client had a phase 4-phase visitation schedule, which once she got into phase 4, she could then petition for the child to come home. I got appointed in February, and when we came to our hearing, I believe it was March 7th, Your Honor, we'd indicated that we wanted to amend the phase 4 schedule. And so it has been put over. We filed our motion to amend the phase 4 schedule. So that is what's before the court. Also, phase 4 hasn't started. So we're here today on our motion to amend the phase 4 schedule. I know that the guardian had also filed a motion, but she hasn't cited it on.
Let me see here just a second.
Yes. And for ease, our pleadings were filed March 14th.
All right, and I did receive those, Miss Gill. It looks like those were filed and we received a copy, at least here, April 10th. That doesn't have a hearing set. Let me see here.
I didn't know I had to set a hearing. I just guess I was thinking I had to submit something as my side of it. So that's on me that there is no court date for it.
And I tried to ask Miss Gill what she was trying to do. Is this a response or a motion? And she wasn't very clear. So certainly she has her right for the motion, but she would need to cite it, give us notice.
I guess my concern on this case is when I look back through this, this looks like something that this started back in October of 2022. And it was there ever a guardian ad litem in this case?
Yes.
Yes,
this
and then they were
actually-
dismissed.
The guardian ad litem was dismissed when I got final order for guardianship.
Okay.
The original case started back in 2018, and then when the laws changed, they told me in order to be seen in front of the judges again, I would have to file a minor guardianship because we could no longer file into the other case. So it's an extensive,
Right.
It's gone on for a long time.
Right. Yeah, this is one of those that got caught in the middle.
Yeah.
All right. So I guess my question, and again, this is one of those, I was just trying to make sense of it because it was a bit of a kind of a convoluted history because of that.
Yeah.
There were a couple of different orders.
So for the final orders, Your Honor, in terms of the final residential schedule, while they were made, I believe in 2019, if you look into this matter, they were filed under cover under December 12th, 2022. So they were filed into this case, but there were actually orders that were made earlier. They were just made in the third party case. And so that order that was filed December 12th, 22 outlines the 4 phases.
Okay, and we're currently in phase 3, as I understand it.
Yes, we were supposed to
Yes.
move to phase 4 in March, which the parties haven't. We had, and I believe that was because we indicated we were going to be filing a motion to amend it, phase 4. There's been no objection, so I think at a minimum, depending on what we do today, we need to start that if we are going to appoint a GAL.
I
But
do
my
have
client,
major-
hold on, sorry, I'm not done yet. Thank you, Ms. Gill. So we do have the motion today before you, Your Honor, to just simply amend that phase 4 schedule by a couple of nights. And that's what we have before you. I'm not 100% sure with everything that Ms. Gill filed, what was actually supposed to be in response. So what I did was took her first declaration that was 12 pages long and utilized that as a response. And so my client wants to proceed on the motion today.
Well, so is this a motion for adequate cause to modify?
It's just a motion to amend the schedule for phase 4. Since we're in phase 4, we had discussed it at the hearing in March, and they said if we want to amend, to file a motion.
The reason we did that is the way the plan is set up, phase 4 goes from me having him every weekend to me having him every other weekend. And with the connection and the relationship that we've built, I think it would do more damage than good to go to every other weekend, because he's used to seeing me every weekend and he's been asking for more time. So we went ahead to try and amend it in his best interest, so we don't lose that connection and the establishment of mother role.
My only concern, Your Honor, is that our original plan states that she cannot have overnights before having adequate housing. And 2 weeks ago, I was notified by the person that owns the home she was living in that she was squatting and was not a tenant and she was evicted. So the last 2 weekends, she's been camping in her boyfriend's family's yard, which I do not think is adequate housing to have her overnight visits. It's very concerning. He needs stability and routine, and camping is not appropriate. I've submitted documentation of the text message I received on Facebook from the owner of the home, and I also talked to her about that. But I don't think it's appropriate to be camping every weekend when you're homeless and you don't have a home to take your son to for visits.
Your Honor, I'd like to say there is a civil matter between us and the landlord. I have had to call the sheriff multiple times, and every time they come out, they tell us this is a civil matter, that she has not served any eviction papers. She has not done any of the legal actions that she needs to do in order to have us leave. We are currently looking for a new apartment. I have scheduled meetings this week with 3 separate landlords. I am currently staying with family in an RV that's got a bed, it's got a shower, it's got a kitchen, it's got everything that he needs. It's not ideal, no, but it is adequate enough to continue my visits. It's only temporary. I am moving as fast as I can. We still have all legal rights to be in this home out on West Side Highway. I just have chosen, because of how hostile it has gotten between the landlord and us, to not put my son around that, because he doesn't need to see anything like that. And they have been very aggressive and hostile. So for his best interest, I've just moved the visits to family where he's safe, where the people here are approved through CPS as guardians, and they're mandatory reporters, so everything is safe for him. I'm doing all I can to get into an apartment as fast as I can. I've got all the money for it. I'm just waiting on the approval from the landlords.
Okay, and you have a valid license and insurance, yeah?
Yes, I have a CDL license right now, Your Honor.
So that's why we brought this, Your Honor. It's not that she's trying to make some crazy adjustment. It's just with her current plan right now, she gets every Wednesdays after school and every Friday overnight. And phase 4 has us going to every other weekend, Friday to Sunday. So it's the same amount of time, it's just allocated different. But the whole point is to transition Gage home, and going to her seeing him 3 times every week to 3 times every other week is going to be detrimental to that bond. And so we're just simply asking we had 2 proposals for a schedule, either adding on that Saturday every weekend for the first 3 weekends, or doing like a Friday to Sunday one weekend and then Friday to Saturday the other weekend, to kind of keep that bond up. And I think it's important to note, Your Honor, until Charity had me appointed and we started conversing in March, these issues hadn't been brought up. These alleged issues hadn't been brought up to the court. There was no motion. There was no request for a GAL. It's just when my client finally put her foot down and said, I want to move forward, it's time for my son to transition home. That's when the guardian started getting upset, which I get it. She's had him for 5.5 years. I get that there is a strong bond and everything, but it's gotten to the point where, due to the guardian's actions and her harassment and her hostility, my client had to file an anti-harassment order against her to get her to sort of calm down. And I understand, I really get it. It happens a lot when you have a child for that long. But at this point, we have to work on transitioning home. It's not appropriate for the guardian to be saying, you're my son, I'm your parent, this is not your mom.
I don't say that.
Excuse me, Miss Gill, if you could just wait. It's really like sad at this point. It's just, now we don't want to move forward. So we're simply asking to add those additional time and proceed on our motion today. Of course, we do have more to say than, just that. I just wanted to give the court a brief overview.
Okay, well, I guess here's the concern I have. This is a court order that was put in place back in 2020. I assume there was a guardian ad litem that may have had some impact on that proposal or that phase. And I think absent a guardian ad litem input on, I mean, it seems to me we're on this, if she's complied with phase 3, then we move to phase 4. But if you want to change phase 4, I'd want to have a guardian ad litem look at it.
Okay, then we would ask we
I
move
would.
into phase 4 today, and that, and if we want to change it, I'll speak with my client afterwards, and we'll talk about appointing a GAL. So we would ask that phase 4 starts immediately, which includes her Friday to Sunday starting this week, and then I'll discuss with her about amending phase 4 and appointment of a GAL. There's been nothing before the court that's been brought that says stop phase 4 or anything like that. We even have the guardian who wants my client to have every other week in the summer. So, Your Honor, we'd ask that phase 4 then starts immediately. And then I'll speak with her about amendments and appointment of the GAL to amend that.
Ms. Gill, and I did review your and I mean, I think there's some concerns raised. I don't,
And I did file a response to that, Your Honor. It just hasn't come across for you
Okay.
to be able to see it yet.
all right. So here, I guess here's where we're at. If she's completed the 6 months under phase 3, then we move to phase 4. And then if there needs to be some adjustment under phase 4 or some other issues, that can be brought back before the court, and we could take a look at a guardian if we need that.
Thank you, Your
So-
Honor. And just to note, my client is also 31 months sober this month, and she submitted all of her hair follicles in UA. And then just to be clear, Your Honor, since it is an every other weekend phase, can we have the order that her every other weekend starts this weekend?
Ms.
Your Honor,
Gill,
my
Go
only
ahead.
concern is, so I am not opposed to having more time. My problem was for like 4+ months, she would not tell me where she was taking him overnight, which caused more and more problems because I wasn't allowed to even know where he was at. And I really do not think it's appropriate to go up to more overnights, sleeping in a camper in the middle of Kelso or sleeping in a field out of somebody's yard. If she's really trying to be responsible and get her son back, camping every weekend is not appropriate. And it's not stability for him. He's not getting baths, he's not eating, he's not getting homework done.
That's not true,
Your Honor,
I'd
we're
like
gonna-
to-
Well, hold on, okay. If he's camping for every other weekend, that's certainly not gonna hurt a child of 7 years old.
The only reason we
Ma'am,
actually went
Ms.
camping.
Johnson,
Sorry.
just sit tight for a minute, okay? Okay, you've got an order in place. We're gonna follow the order unless I see a reason. And if we want to modify that, then I want to guardian ad litem to weigh in on it and see. This was put together 4 years ago. I assume a lot of circumstances may have changed, which may change that order, but I think I need to see something that indicates that.
Thank you, Your Honor.
So if it's been the 6 months, then we should switch to phase 4, which would start this weekend.
Thank you.
So it'll be every other weekend, Your Honor?
That's what it looks like in the order, phase 4. I'm looking at the order it's in the.
Yes, Your Honor. It's every other weekend, Friday to Sunday.
And not Wednesdays. It's just every other weekend in our order.
Wednesdays was granted to me under the minutes in a previous.
Well, I'm looking at the order that's in front of me, which is the order we're working under, which talks about what phase 4 is.
Yes.
So phase
Okay.
4 is whatever it says, and I'm trying to locate it here. Yeah, phase 4 also includes the language for adequate cause if that's completed as it states. And it's basically every other weekend is what it indicates there.
I believe, Your Honor, what my client was referring to is after this. I'm not sure if it was I think it was Commissioner Nelson. There's a bench order that adds on every Wednesday. So there's a subsequent bench order from Commissioner Nelson that adds on the Wednesday visits.
You know where that is?
Yeah, I'm gonna if you give me one moment, I'm gonna find. I apologize, Your Honor. Let me find it right now. September 5th, 2023 bench order.
Hmm.
And then let me open it up. I believe it looks like Commissioner Nelson, but it is a 2-page bench order and it's handwritten.
I have that. Let me just a second here. That does, it looks like it adds Wednesdays 3 to 7, or it could be from 2:15 to 7. It's not, I mean, I have no idea what the intent of that was.
That was just me offering more time during phase 3 for her.
Unfortunately, not the intent was to offer additional time. There's been nothing stating no Wednesdays. So we would just ask we move forward with phase 4, continue the Wednesdays, and either party can bring it back if necessary.
All right, that sounds appropriate. I mean, again, I don't know what the basis for that change is. If it was an agreement, that's one thing. So that would stay in place, and then we go to the alternate weekend starting this weekend.
Can I
Thank you, Your
ask a
Honor.
question real quick?
Sure.
Could I, on the weekends that I don't have him, there is a protection order, so obviously I can't call Miss Gill herself, but I was wondering, could I have at least like some video visits maybe on Saturdays and Sundays through my if my boyfriend calls Carmela's phone?
I'm gonna leave it as is unless we have
Okay.
some, and if you want to modify it, we can certainly look at that and, get a guardian appointed and determine if that's appropriate.
Okay.
Your
Thank-
Honor,
Thank
the only issue also I have is I have alleviated her pickup by allowing her to pick him up from school, but she's been changing my pickup location every weekend. We were meeting in Four Corners in Castle Rock at a general store in public. And then once she started camping, she wanted me to meet her in Longview, or she wanted me to drive to Kalama and meet her. And I would like to just have one place I could please pick up, so I'm
makes
not
sense.
messed with.
Is Four Corners was the prior place everybody was using?
Yeah,
It
Uh,
was.
over a month.
Hold on,
No.
Your Honor, hold on, Charity, hold on. The order, Your Honor, says, picking up parent, or picking up, like we see in parenting plans, picking up parent at residence or school. So that's what the transportation order says. And it's all the way back in that final residential plan. It hasn't been amended. We can certainly like work on it, because I think having one solid place, and I've tried to work on this with Miss Gill, either one person's gonna pick up or always gonna have a halfway point. The problem is she wants my client to pick up and she wants a halfway point. So I believe we need to stick with what the orders say, absent an agreement. And the orders say picking up parent or guardian. And
There's a
So
protection order now, though.
there's a carve out in the protection.
Yeah, there's an exception for us to have contact for pickups and drop-offs.
Okay, what is the protection order case number?
Let me 24-2-00726-08. I believe that's a 7,
That's not, wait a minute here.
or maybe that's a Z.
I have it, Your Honor. It's 24-2-00226-08.
Thank you. Let me just look at that. I want to make sure we don't get either of you into any trouble. So let me look what that says. Looks like that's actually in the process of the hearing on that next week.
Temporary order is issued 3/14. It's been continued a few times.
Oh, I see. Okay. Let me see. I'm
And I
not-
believe what happened is that the initial temporary order that was issued on the bench, Your Honor, didn't include the carve out. They went to the hearing and alleviated
Okay.
the carve out.
Direct contact between parties allowed for child pickup and drop off between the parties.
Yes.
So here's what, I guess what we'll do.
Law enforcement has the most recent one from 4/8 that does not have the program.
They should have it because it extended the 325 order.
They replaced it with the next one, so the one from 4/8 is the most recent.
Well, I mean, the order's still in place with the original terms. Well, I guess here's the problem. It looks like when that order was extended on April 8th, it did not include that carve out, even though I think the carve out would still be valid, but it still could result in a law enforcement interaction because it's not in the order that they're going to be looking at. And I don't know what changed that here. So
Before the exception was put in, Miss Gill and my boyfriend David Lee were doing contact to do exchange. That was working out really well. Both of them were civil to each other. I think that could be agreed upon to stay if that's the situation.
Yeah, I was meeting him at Castle Rock, and because we were 20 miles apart, our houses at the time.
Okay.
So I,
So I guess at this juncture, I'd be concerned about having direct contact because of the wording of that extension order. And that's not back on for hearing again until it looks like next Monday. So
We can have, yeah,
whatever happens next Monday, if there's an ongoing order that needs to have some language in there about this issue,
okay.
whether it's a permanent or a temporary, but between now and then, I think going through the boyfriend probably makes sense to make those arrangements. And then Ms. Gill, if you and Ms. Jocelyn can discuss an agreement on the transfer a location or something. It seems to me having one place that everybody goes to all the time makes the most sense. That's not really a change in anything other than dealing with this new situation with the no contact order.
I've not
We've
had
been
very
doing the
much luck
manual.
dealing with Miss Jocelyn on that. I've asked for weeks now to have a concrete pickup, and she pretty much tells me, I'll check. You need to get a hold of them. You need to get a hold of them. And
Okay,
it's just
well,
changed on me.
well, hold on. Where's everybody? Whereabouts do you live at, Ms. Gill?
I live in Longview, right by the lake.
Longview by the Lake. I mean, Ms. Johnson, where are you living at?
Right now, because of the issues with the landlord out at West Side Highway, I am staying in Kelso on Elm Street.
Okay, so pending getting a resolution in this, why don't we have you do an exchange here locally instead of driving to Four Corners or something?
Yeah.
Maybe we use the McDonald's on Ocean Beach, the one downtown, not the one out on Ocean Beach.
By the dollar store?
Correct, correct. And that's a reasonably good place because they're always open. They have cameras there, so it's a reasonably safe place.
I agree.
Okay.
and is that only for the exchange at the end of visits? Because my client picks up at school, or do you want the child to be picked up from school and brought there?
I think it's probably, if you pick it up from school, that makes sense because it's not
Okay.
any interaction between the parties, but for the return, let's do it at McDonald's in Longview and that'll save everybody some drives.
Okay.
Perfect. Thank you.
Thank you, Your Honor.
So then on this case, we don't need to extend any orders because there's already, we're just waiting for, do you want to start another review on this or just let it go at this point and see if anything needs to be filed?
I think at this point, let it go, Your Honor, because they have avenues, like you stated before, to re-cite it on, but they also have provisions of what my client needs to do to ask for the child to come home. So I think at this point, just follow the orders and cite back
Okay.
on if needed.
Okay, so the only thing I would indicate, it might be useful to have something indicating that exchange place will be McDonald's, just so there's clarity there. If not, I mean, I don't think we have to have that, so.
Your
No, I
Honor.
think,
Oh, go ahead.
Yes, ma'am.
ahead,
My
Ms.
only other concern of why I do want it reviewed is because them wanting to modify phase 4 doesn't take in consideration that Gage is going to be out for summer break. And I think that there should be a summer schedule in place to where it's not just weekends that she has him. She'd have more responsibility of him, which would be helping benefit her for a transition home. And that's why I was really hoping that there would be like a guardian ad litem, just because it's a very awful position for me to be put into to hold her accountable. And with the protection order, I can't even ask her for UAs anymore or anything like that. It's really like put a bind on what I am allowed to do or contact her about. But I do think that we need to have it revised for a summer schedule for him.
And I'm happy to work with Miss Gill. My client will do the week on, week off that she proposed, but we do have the phase 4 that states what my client needs to do and what is the basis for AC. So at this point, she can bring it forward. If Miss Gill still wants to do the week on, week off, I'll talk to my client afterwards and we can reach an agreement and send a stipulation into the court. I don't think there's a need to review this. There's
Yeah,
nothing
because
in
the
the
order
plan.
doesn't state a summer
Hold on,
schedule.
Charity, hold on. We have the orders in place and each side knows what they need to do if they need to modify it. This was a plan. is set forward. I will talk with my client after this hearing about week on, week off. And then I can send over stipulation to Miss Gill to sign to convert it for summertime for that. And we can agree on a pickup and drop off time and day.
I was only
if
willing to agree if a guardian ad litem could investigate wherever he would be staying because
Well,
going a week
let me
on-
stop, let me stop you both. So this, I've got phase 4, which talks about 18 months. Something,
For me to be clean that long, and I've been clean for 31 months.
ma'am, I can read, okay? So
Sorry, just
I don't know when that runs from, if that runs from the phase 4 starting, or if that starts from some other point. So that may be an issue, but in any event, the phase 4 is a visitation schedule. It doesn't say a week on, week off. So if you guys agree to something else, that's fine. If you want to bring it back in, we have a guardian appointed to look at a modification of that. That's fine too. But right now it's phase 4.
Thank you, Your Honor. And
Okay?
just for housekeeping, as I was appointed, does the court want, since we're done, does the court want to relieve me today, or how does the court want to handle that moving forward?
Absent there being any, I guess my thought would be is, why don't you talk with your client, see if there's any need to do any adjustments of any kind, because it'd make more sense to just deal with that than go through a reappointment process if we need to.
Okay, thank you, Your Honor. Appreciate
All
it.
right. Okay, if there's no need to, if you want us to send in a final order relieving you and with the billing.
Okay. Okay, thank you, Your Honor.
All right,
thank you, Your Honor.
all right, good luck.
Thank you.
The guy makes over $100 grand a year. My client makes $800 a month.
She locks up all of the food, the toiletries, and requires him to bring food for himself and the children 3 nights a week.
But he's just stopping over for 10 minutes here and there, and it is disruptive to the family. It's disruptive to the kids.
However, Miss Garcia literally locks up the toilet paper.